Patrick.
Hi, Shigeri. Yes, can you
Hi,
hear me?
how are you? Okay, good.
Great. On, are you there? Zakaria?
Good morning, Patrick. Yes, I'm here. I hope I'm audible.
Yes, you are. Great. On, please confirm you're available and adjust your mic.
She's available. I think she's preparing her microphone in a few.
Oh, okay. Then.
Zakaria, we need to get a confirmation from her at least so that we can be sure the mic is working.
Okay.
Sorry about that, Patrick. My mic was misbehaving. I hope I can be heard.
Oh, great. Yes. Fine. We're good. So let's just wait for the attendees to join, and then 11:05, we kick off.
We need to join with a few devices just in case, or this will be sufficient.
Sorry?
We need to log in with a few devices, maybe the computer or the phone. Able to promote us with the two devices. I can try logging in with another one, just in case, because I know the network here might fluctuate.
Well, how many devices do you have?
Yes, for me, just two.
Oh, okay. So perhaps in case there's intermittent networks.
Yes.
Okay, fine. You will just prompt me via message, and then I'll pick it up. All right, so let's wait for people to join, and then we'll begin. Good morning. Good morning, ladies and gentlemen. Welcome to our last series of webinar. And this one will be touching on our company's registry and movable property security rights registry. And we have on board our speakers for today. And I would just like perhaps to give 5 minutes for participants to get in before we finally kick off. So 5 minutes will do. So we begin at exactly 11:06 a.m. Thank you. All right, ladies and gentlemen, good morning. Once again, my name is Patrick Lavens Wandari, Advocate and Legal Counsel at KEPSA. And today marks the last series of our BRS KEPSA engagement webinars. And we have on board our speakers for today, Ann Kanake, Zakaria Mwangi, Ms. Shigadi Mwakir. So I would just like to do an outline of how the presentation will proceed. And just to save on time and cost of the same, well, the first presentation will be from Shigadi, who will be talking about the introduction and BRS overview. Then we will move on to Zakaria Mwangi, who will speak on compliance, linking, and annual returns of companies. And then we will move to Ann Kanake. Ann Kanake will be talking about beneficial ownership. Then Shigadi will come in once again to talk about the movable property security rights and conclusion of the same. And then after the presentation, we would have all questions answered. So the chat box is open for you to lay in your questions as the presentation goes on. So I would just like to introduce our speakers for today. We have a rich panel at hand, and I will begin with Ms. Shigadi Mwakir. Ms. Shigadi Mwakir is a Deputy Registrar at the MPSR Registry and or department. So she's an advocate at the High Court of Kenya with over 6 years experience in commercial law and legislative drafting. She has been instrumental in the various legislative reforms under the BRS that lead to the improvement of Kenya's standing in the World Bank Doing Business Ranking Index and in protecting minority investors indicator, getting credit indicator, and also resolving insolvency indicator. She was involved in the development of the movable property security rights regulations of 2017, the company's beneficial ownership information regulations 2020, which I think will also form the basis of Ms. Ann Kanake's presentation, and the draft partnership, limited partnership regulations of 2020. She has also been instrumental in the secure transactions legislative reform in Kenya from 2017. Then lastly, she is a member of the task force on national risk assessment on money laundering and terrorism financing, and also sits in the ease of doing business transformation team that has been responsible for the improvement of Kenya's standing in the World Bank Doing Business ranking. So that's the rich CV that Ms. Shigadi Mwakio has in store. Next, we move to Ms. Ann Kanake. Ms. Ann Kanake is an advocate of the High Court of Kenya with experience working in various legal capacities in the private sector. She holds a Bachelor of Laws degree from Moore University and a postgraduate diploma in law from KEPSA. Ann is currently a Senior Assistant Registrar of Companies at the Business Registration Service. Lastly, we move to Mr. Zakaria Mwangi. Mr. Zakaria Mwangi is an advocate of the High Court of Kenya and holds a Bachelor of Laws degree from KISS University and a postgraduate diploma in law from Kenya School of Law. He is currently an Assistant Registrar of Companies at the Business Registration Service. So ladies and gentlemen, and our esteemed attendees, this is the rich panel that will take us through our topic of today. And I will be your moderator for the day. And we would just like to proceed right now. So the webinar kicks off right away. Over to you, Ms. Shigadi.
Thank you so much, Patrick. So I'll speak briefly about business registration service and just an introduction of what we do. And much as we're going to give a lineup of the company registry and the MPSR registry, it's important that you are, I know you've already discussed the official receiver, but it's important that you're well versed with the other registries that are within our armpit. So a business registration service is a state corporation under the Office of the Attorney General, we have a board of directors, and it's headed by a Director General called Mr. Kenneth Gadhuma. So under the Business Registration Service, we have the official receiver who deals with the licensing and supervision of insolvency practitioners. It also deals with the administration and supervision of bankruptcy of natural persons and administration and liquidation of companies. Other than the official receiver, we have, and the official receiver is headed by Mark Gakuru, who is an official receiver. We have the company registry. Under the company registry, we administer various laws. We have the Registration of Business Names Act. We have the Companies Act. We have the Partnerships Act. We have the Limited Liability Partnerships Act. And under those, I would say that the company registry is the central repository of public statutory information on companies, limited liability partnerships, limited partnerships, and business names. We also have the MPSR registry, which administers a legal framework that seeks to govern the use of movable assets as collateral. I'll speak more about the MPSR registry in my presentation. And then lastly, we have the hire purchase registry that deals with the licensing of hire purchase businesses. So in a nutshell, that's all about the business registration service. I'll hand it over to Zachariah, who will take us through the company registry. Thank you.
Thank you, Shigadi. I'll be very brief and I'll talk about a few things that we do here at the company's registry. Now, we've talked about the various types of companies that are registered with us, but that is not all that we do. We also maintain their records. So we do registration and maintenance of all those types of entities that Shigadi has spoken about. And besides that, we also do perfection of charges. If you register a charge at the lands office, you'll also need to come here at the company's registry if it is in relation to a company, and we'll issue you with a certificate to show that actually that company has charged its property. So I'll take you quickly through some of the compliance requirements that we have under the Companies Act. So we are going to confine ourselves to companies at this point. Now, every company is required to hold an AGM at least once every year. Now, it does not depend on the type of company involved in this case, whether it is a family company, it's a company formed by friends, it's a public company, it's a company limited by guarantee. You are required to hold an AGM every year. Now, there are some leeway that you can have, that is, you could write to the registrar under section 275A requesting for an extension to hold an AGM. Let's say that you're supposed to hold an AGM today. That is when your year comes to an end from the time you are registered. But you find that due to one reason or another, you're not able to actually hold that particular AGM. You could write to the registrar, giving reasons as to why you are seeking an extension for time to hold the AGM. Now, but this is not something that should be misused, because as you know, we have the guidelines which allow us to hold virtual meetings for companies, and therefore, unless there are very straining circumstances, that is when that should be used. Now, another requirement that we have for companies is the requirement to file annual returns and financial statements every anniversary of the company. That is to say, from the time the company was formed. Or the alternative is, if you filed your annual returns today, then your anniversary would be either the registration date of that company or that anniversary of the time that you actually filed your annual returns. That would mean that if you filed today, then next year, the same time, you'll be required to file your annual returns. Now, as a company, you can have any shareholder you want, so long as they are registered legal entities. But for directors, you can have also directors who are legal entities, but you must have at least one natural director in the company. Now, for public companies, we require that at least 2 directors to be appointed by the company. We also have the requirement to have a certified secretary for public companies. For private companies, if you have a capital that is 5 million and above, you'll be asked by the registrar to appoint a certified secretary so that they can aid you in terms of compliance. Now, you'll notice that over the life of a company, you might need to do a number of changes, and that would include amendment of articles, change of shareholders, change of directors, change of secretaries, even reporting the resolutions that have been passed by the company. Now, all these changes must be reported to the registrar. So it is not a matter of the company simply holding an AGM, appointing directors, and then it stops at that. You have to actually take a step and make sure that the registrar is aware that you as a company has appointed new sets of directors. And we have the statutory forms for all type of notifications. Now, if you look at our regulations, you're able to find the various types of forms that you can use to make notifications to the registrar. That information is also found on the BRS website. Lastly, I have set aside the beneficial owners as a different set of requirements, which will be discussed by Ann Kanake shortly. So I'll not venture so much into it. Now, you'll notice that most of the companies that we have were registered before the BRS went online. And that is to say that the records are either manual or held in systems which are not as developed as the citizen platform that we have at the moment. So what we require of companies which were registered before before 2017 is that they have to actually link. And I think towards the end of my presentation, I'll try to show you how we go about that. So what is the purpose of a business or a company? We want to migrate you from the files that you have to an online system where you can actually have access to your company simply by connecting that with your ID. If you go to the BRS website, if your company is linked, you are able to see the company and its particulars. If it is not linked, you're not able to find that particular information. And therefore, it is prudent for you to make sure that you update your records online if you own any company. Now, you notice also that most of the companies may have made changes over the years, but they've not reported to the registrar. So this is an opportunity to actually ensure that the records held by the company are the same as the records which are held by the Business Registration Service. Therefore, you'll not be asking for the position of the company, and then we provide a different status from that which is known to you as a company. Now, we collect information relating to the entity, that is to say, the address of the company. We also collect the shareholders and directors of the company, which is a company which is limited by shares, and members of the company if it is a company limited by guarantee. So it is, for those who've interacted with our registration system, the kind of information collected there will be similar to the kind of information we'll be collecting during the link business application. So one of the benefits that you're going to derive, besides being able to see your company in your portal, is that you are able to access our services more quickly. If you want to, for example, change the officials of the company, you're able to access that service online. If you want to check the status of the company, you're able to apply for a CRL or what we call an official search. And that search will be automatically generated, as opposed to companies which are not linked, which have to go through a process, and that will take a few days before you get your results. Now, there are risks which you face as a company if you do not link a company. And one of the risks is that if we find that your file is not active for so many years, And at least a company which has been linked online, we are aware that it is active because at least you've taken steps to bring your company to compliance. But for companies which are not linked, you'll find that probably it was registered and nothing happened in the file over the years. So if anything happens and the registrar inquires whether the company is carrying on business, the likelihood of us getting a response is very low because you remember back then the information that was being provided in terms of address would be postal address, and that might not be sufficient to get in touch with the directors of the company. So once the inquiry is completed, you'll find that the company may end up being struck off, and that is one of the major risks that you face as a company if you're not linked. Again, just to notify you that government entities are moving towards enforcing compliance. And you'll find that if you're to transact with most of the government entities, you'll be required to at least have your records updated with us. So you'll find that someone will write to us asking, has this company filed annual returns up to date? And for you to file annual returns, you'll need to have linked the company. And therefore, you'll find that it means out on business if you are not linked and verified. So that is all about link a business. I'll be doing a short demonstration to show how that is done. Now, I have annual returns as a requirement, which has to be yearly, done yearly. And just a caution here, we have been having a confusion as to what type of returns we file at the company's registry. This is different from the KRA returns, KRA tax returns, which you have to file with KRA. So this is strictly on the position of the company and whatever has happened over the company over the year. It has nothing to do with taxes. Um, so you file your annual returns on the anniversary of the registration of the company or the anniversary of the last time you filed your annual returns. I had explained this earlier when I was talking about the requirements for compliance under the Companies Act. Now, this is a chargeable lodgement, and we charge 1,000 shillings for lodgement. That is, every year the company will file an annual return and be charged 1,000 shillings. Now, if you happen to file your annual returns out of time, you'll be penalized 500 shillings on top of the 1,000, such that for every late year that you file your returns, the charge will be now 1,500. So that is all in terms of the cost. Now, the forms currently do not require you to feed a lot of information because they will be automatically generated. All you need to add is the date of return, and then a form will be automatically generated. And then the only thing that you'll have to do is tick a few boxes and then sign, upload the form, and your application would be reviewed by the officials of the service. Now, what is the content of the annual return form? If you go to the BRS website, you're going to find the form. It's referred to as AR29. It's a statutory form prescribed by regulations. And we have the specific content of that form. Among the information collected by this form will be the registered address of the company itself, its registration number, the directors of the company and their addresses, whether the company has a secretary, that information should be provided there. If you have any person who has been authorized by the company to transact on its behalf in terms of if you authorize someone to file some lodgements with us, for example, that information should be captured on the annual returns. You should also capture the statement of capital of the company. That is to say, if the company has a capital of 500,000, that should be captured. And then you should also be able to indicate who are the shareholders of the company and their addresses. Now, if you look at the form, you are able to also tell if there was a change in shareholding, because the form is supposed to capture that. In the course of the year, if I had 10 shares and I transferred the 10 shares to Anne, that transaction should be captured in the form. So it captures the happenings of the company within that particular year of return. So Other things to note. We have talked about the fine which is charged by BRS, but you know our compliance system is based on imposition of offenses. So if there is any aspect which the company has not complied with, then an offense is usually created, and that goes also for annual returns. Now, I have talked about the changes being recorded in this particular form, but just to add that this is not a document of change, and proper lodgement has to be done for changes which have taken place in the company. I talked about the different forms which are available on our website and under the regulations of the Companies Act. And therefore, every company should be guided by those forms to report exactly the change that took place over the year, such that an annual return is simply a summary of whatever has happened, but not a document to notify the registrar that a specific change has taken place. Now, again, it has to be done in the prescribed form, as I've explained earlier. Now, that is it for annual returns. I could do a quick demo for link a business. I think for annual returns, we have a little bit of a challenge, but I'll get up to the point where probably it will be possible to explain further. Just a minute. So this is my eCitizen account, but you'll notice that it is not the original eCitizen account, although they are the same in terms of appearance. It is a test server, so whatever I do here is only a dummy and will not affect any company or any transaction for that matter. So if I log into my account as a user, this is the information I'm going to find. I'm going to find my companies listed up here, as you can see, and the status alongside that particular company. So for example, I have Utafiti Bora Limited with the registration number. You'll notice that it is not verified. That is to say, it is not linked, but it is published, meaning that it is available on eCitizen. If you try to search for it, you're going to find it, but that its information is not verified. That is to say, it is not linked. If you look at this second part also, you're going to find that it lists the BO status, which Anne will be explaining later. You see, for this one, the BO is complete, meaning that the person has filed beneficial ownership information. And this one, the BO status is pending, meaning that they have not filed the beneficial ownership information. So I'll try to link the company very quickly. This is what happens when you view the company. This is the landing page for that particular company. So you'll go to maintain a company. You'll find that on your left hand side, you have quite a number of options, including annual returns. So you select on annual returns. Okay, this is for annual returns. But I'll use the other company to demonstrate annual returns, because this one has a challenge. You can see it's bringing an error. So for annual returns, I'll use the other company. Let me demonstrate first how to link it. Okay, for the link a business, we'll go to link a business up here, as you can see, and then we'll search the company involved, that is Utafiti Bora. Then search. As you can see, it will bring results, including the registration number. So you only select, then go to next. This is the first step. It provides the registration number, the business name, type of registration, whether it is public, private. You are able to edit at this point, because sometimes you'll find that the information is not accurate, and therefore you are allowed to edit. If it is accurate, you proceed to next. So you can indicate the capacity, say I'm a director shareholder of the company, and then indicate what is the object of the company, and then go to next. As I said, you'll have to update your registered address as a company. Therefore, we will select randomly for the sake of demonstration. So where we have the asterisk sign, it means that the information is mandatory, and if you leave out that particular set of information, you're not able to proceed to the next step. So we can proceed and continue. As you can see, this is the share capital of the company. It means that you have number of shares, which is 100, and the value of each share is 1,000. It means that the nominal capital of the company will be 100,000. So we proceed. So here we are supposed to provide updated information of each director and shareholder of the company and secretary if there is any. I'll select myself. I have to choose my designation, whether I'm a director shareholder or a director or a shareholder. So in this case, I'm a director shareholder. I'm a Kenyan citizen. Then I add my ID and my first name. All I need to do at this point is to verify, and the rest of the information will be populated, including my date of birth, KRA PIN, and my full name and gender. So I'll need also to update my phone number, my email, and again I insist that this information is very important, because if we're doing changes, this is the email that we are going to contact you with. If we need to reach you as the registry, this is the information we're going to use. So if you provide information which is inaccurate, then it means that you're unreachable. And remember the consequences I said about not being able to be reached on the inquiry as to whether you're carrying on business. So my passport, attach that. Then that is my residential address. You're supposed to populate the information, but at this point, the information is populated. Now, the share information, I have 50 shares in the company. Remember, the company has 100 shares, so I hold 50. The 50 shares have been fully paid up, so that is what that means. And then we have the section on beneficial ownership information, which I think will be discussed shortly. But for the sake of this demonstration, because this information has to be provided, remember I own 50 shares, which is a half of the shares of the company. So I have 50% shareholding. So this information is in terms of percentage. Voting rights also, it means that we are equal shareholders, we have equal voting rights. So again, it will be 50%. Whether I control the company directly or indirectly, this information must be captured. If it is indirectly, then if I'm holding the shares on behalf of someone, that should be also disclosed. Then we have to indicate the time when I became the beneficial owner of the company, and also provide the information as to who actually provided this information. Is it myself? Is it an authorized person? Is it a third party? Is it another official register? So all that information must be provided, and then we submit. So we have also to update for Anne before we proceed to the next step. And again, the phone numbers, email addresses must be carefully entered at this point. I need also to update a passport photo, residential address also, but in this case it is auto-populated. The bio information is the same because they hold the same number of shares. Therefore, we can proceed. Now, this brings us to almost the last step. Now, this tab on beneficial owners, remember when I talked about whether you hold the shares directly or indirectly? If you hold the shares indirectly, then it means you have to add another person who has nominated you to hold the shares on their behalf. And therefore, this is where you add them. If there is no other person who is involved with the company, you can save the changes and proceed. Now, a form will be generated here, which is the BOF1 form. So this is the form. I'll be displaying it shortly. Then once you upload it, you finish the transaction. So this service is not charged. It is a free service. It means that the moment you submit, you need only to note of this application number, which will be your tracking number. Therefore, you need to follow up and see whether it has been approved or not. This is the number to use. So once you submit it, someone on our side will look into the application. If it is proper, it will be approved and your company will be verified. For the sake of demonstration, let me approve it and get back to you and allow you to see how it appears when it is verified. Just a few minutes. I know time is running out, but I need to complete this quickly. So I have approved the application. I'll take you back to the landing page for you to see my businesses. I don't know whether we'll be having more time at least so that we can go through everything. So as you can see, Utafiti Bora is now verified. It means that we've actually properly linked the company. Now, I had promised to share with you the bill of account form, but I don't know, at this point, I think we can have that discussed in the next session with the next presenter. But quickly allow me to try and file annual returns for this other company. So we go to maintain a company after viewing the company, annual returns, select submit returns, and then you'll notice that now this company displays all the years that the annual returns have not been filed. So you're supposed to start with the earliest in time. You select the date of return. So this company was registered on 25th April, and therefore the next anniversary will be April of the next year. Therefore, we can select April, any day in April, so long as it is not after 25th. Now, as you can see, there is an option to download the annual return. So you'll only download it. There are a few sections which you need to click, that is to select, and then sign, upload. And that should be repeated for all the other years, and then you submit. The bill will be towards the end when you're submitting the forms for approval. So that's about it. For the meantime, we are not able to display the form because of a technical error there. Because this is a test server, it is not fully developed to handle all the requests that we may be pushing to it. So I'll invite Anne to take over and return to the presentation.
Thank you very much, Zach. Good morning, everyone. I hope I am audible enough. I will take you through beneficial ownership. As you can see, the presentation for a beneficial owner is a faceless person. And the requirement for companies to declare the beneficial owner is to really know who is behind the company. So before I proceed with the presentation as it appears on the screen, I will quickly mention why we are asking companies to file their beneficial ownership information. And I will mention that in 2010, the Financial Action Task Force placed Kenya on its gray list of high-risk countries for failure to combat money laundering, drug trafficking, and terrorism. Kenya was rated as having failed to comply with the 40+9 recommendations of FATF. And following this listing, the government made a strong commitment to enhance the war on money laundering and terrorist financing. Kenya, as you're all aware, is a renowned financial hub regionally and internationally. And because of the previous lax laws on the conduct and registration of business, Kenya was an easy target for money laundering and other financial crimes. And so for this reason, after Kenya was listed in the FATF gray list, Kenya made a commitment to enhance the war on money laundering and embarked on a review of its business laws with the aim of enhancing strict laws to combat money laundering and terrorism financing. One of the popular tools of money laundering is anonymous companies, or what we call shelf companies, set up by criminals in the guise of running legitimate businesses. So they will set up a legitimate company in Kenya, but what is being done in that company is an illegitimate business, such as money laundering or terrorism financing. Kenya made significant changes in its business laws, and in particular, the Companies Act. The Companies Act 2015, which repealed the previous Companies Act 486, was amended in 2019 by adding Section 93A, which makes it a mandatory requirement for all companies to keep a register of their beneficial owners. Further, in 2020, the Attorney General gazetted the beneficial ownership regulations, operationalizing the requirement on disclosure of beneficial ownership. So let's define who is a beneficial owner. So beneficial owner, as set out in the beneficial ownership regulations, sets out 4 criteria for the identification of a beneficial owner. Number 1, a beneficial owner is a natural person who holds at least 10% of the issued shares in the company, either directly or indirectly. So you will hear this directly or indirectly quite many times in this presentation, and I will define what we mean by directly or indirectly. Number 2, a beneficial owner exercises at least 10% of the voting rights in the company, again, either directly or indirectly. Number 3, they hold a right directly or indirectly to appoint, remove a director, or remove a director of the company. And number 4, they exercise significant influence or control directly or indirectly over the company. As Zach was going through the application, he did mention that he either has significant influence or control in a company. So as you can see in our, we can go to the next slide. So we have defined who is the beneficial owner. You have said a beneficial owner is a natural person who ultimately owns or controls a legal entity or an arrangement. Ultimate ownership or control refers to situations in which ownership is exercised through a chain of ownership or by means of control other than direct control. I mentioned direct or indirect control, and I will quickly define what we mean by directly. So direct control, or where you have direct number of shares, 10% shares in a company, Directly means any member, whether individual or jointly, who holds more than either 10% or more than 10% of the issued shares in their own right. Okay, so directly, direct influence means that person holds those shares or is able to exercise significant control in the company in their own right. Indirectly means a person who holds the shares on behalf of someone else or controls or exercises significant control in that company on behalf of someone else. So that is the definition of directly or indirectly. Next slide, Zach. Okay, so why do we require you as a company, as an owner of a company, to disclose who your beneficial owners are? And what are the consequences of failing to disclose who your beneficial owners are? Number one, since the government has made a commitment to ensure that Kenya now is regarded as a safe hub for conducting business and to deal with money laundering and financing of terrorism, in case you fail to disclose who a beneficial owner is in your company, you attract a fine of 500,000 Kenyan shillings. We know that it might be hard to establish who a beneficial owner is because in some circumstances, those beneficial owners may or may not be known even to you as a company. So a company must make all reasonable efforts to identify their beneficial owners. Companies can request the information of people who they believe to be our beneficial owners. So once this information is received by the company, then the company will proceed to prepare its register and file it with the registrar. If you fail as a beneficial owner, excuse me, if you fail as a beneficial owner to submit your information to the company in order for them to register you as a beneficial owner, you risk restriction of your rights or interest in that company, and therefore you risk restriction of transfer, exercise of your voting rights, and receipt of benefits. So both you and your company, if you fail to declare your beneficial ownership, may suffer some restrictions. Next slide. We also mentioned that the register of beneficial owners is a closed register or it's a private register, meaning that the information that companies file regarding their beneficial owners is not available to the public. The information is available to investigative agencies or other competent authorities, which include KRA, the Public-Private Partnership Committee, the Public Procurement Regulatory Authority, and investigative agencies such as EACC, the DCI, or the police. So this information can only be provided upon request. So investigative authorities or other authorities can make a request to the register, a written request to the registrar, requesting to be provided with the beneficial ownership information of a certain company. Say the company is under investigation by central bank, maybe for money laundering, or by the EACC, or by the DCI for one offense or the other, then that authority that is investigating that company can lodge a request with the registrar asking for information on who the beneficial owners may be. Also, information may be provided where the court orders that the information should be given. Disclosing the information contrary to the law is an offense. Also, if a company is going to disclose its beneficial ownership, then the beneficial owner whose information is going to be disclosed has to be notified. Next slide. Well, so that brings us to the end of our beneficial ownership but I would also like to add a few other things that I think will help us understand more who is a beneficial owner. Number one, what information, when we ask you to file your beneficial ownership information, what do we need you to do? Number one, the form, as Zakaria has mentioned, for every information that you enter in the system, then a form is generated. And so what you can see here, this is the beneficial ownership form. This is BOF1 form. And as you can see from the information captured in the system, in the form, number one, we have your full name. Number two, we either have your birth certificate number if you're a minor, your ID number if you're a Kenyan, your passport number if you're a foreigner. We also have your KRA PIN where applicable. We have your nationality. You have your date of birth. We have your postal address. We have your business address if that's applicable, your residential address, your telephone number, your email address, your occupation. Now, this part indicates or shows what is the nature of ownership in the company. And as we mentioned, there is 4 criteria on determining who a beneficial owner is. Number one is how many shares what is the percentage of the shares that you hold in a company. And as you can see in this company, since I'm a shareholder with 50% shares, I therefore have more than 10%, and therefore I'm a disclosable beneficial owner. Number two, it shows the percentage of voting rights I hold in that company, which is equal to my number of shares. Number three, it shows whether I have the right to appoint or remove members of the board. And number four, it shows whether I exercise significant influence or control over the company. So that is the criteria of determining who is a beneficial owner. And as you see, it also has the same information for Zakaria. Right, thank you, Zach. Thank you. So basically that is a quick overview of what is beneficial ownership, why do we require you to file your beneficial ownership, and what are the possible effects of you not filing your beneficial ownership. I would like to bring this presentation to an end, and hopefully we can answer your questions if there are any regarding beneficial ownership. Thank you.
Thank you so much, Anne. I believe Patrick had indicated that we will be taking up the questions once we are done with our presentation. I would now briefly want to take you through the Movable Property Security Rights Registry. The purpose of the Movable Property Security Act is to promote consistency, and most importantly, is to provide certainty in the secured financing, particularly relating to movable assets. So prior to the MPSR Act, we had various legislation that were governing the same regime, that is the security rights. And so you'd find that I think most of us are well versed with the Chattel's Transfers Act that allowed grantors who could be individuals and entities, but you'd find that this regime was limiting some of these entities. For example, the companies were limited. They could not use the Chattel's transfer regime. They were administered under the companies Act 486. This Chattel's Transfer Act also excluded hire purchase agreements, mortgages, charges, debentures, and you'd find that they were all registered under the company's registry. Zakaria, next. Then we do have, and it still exists, the Hire Purchase Act. However, this act was amended, and the purpose of amending the act is to the effect that we no longer take the hire purchase agreements. So we no longer register the hire purchase agreements. What the registry does is to license the hire purchase businesses. And you'd find that for purposes of registering your security rights, where hire purchase is a business is involved, you're required to defer to the movable property security rights registry. Next, Zakaria. So prior to the MPSR Act, we had indicated that we had various laws that were seeking to just administer the security rights. You'd find that there was a component under the Agricultural Financing Act. We had the Stamp Duty Act. You'd find that for you to register the agreements, for you to register under the Charter Transfer as a registry, you are required to pay a stamp duty before you proceed. So the effect of the MPSR Act is to the fact that we no longer require you to pay stamp duty. You find that the Business Registration Service Act was amended, the Companies Act, the Insolvency Act was amended, and the Pawnbrokers Act was repealed. Next slide. So with the multiplicity of laws, you find that we had quite a challenge. So which regime should a layperson, if you don't have a lawyer, which regime should you refer to? You also find that this regime was quite outdated in terms of even being able to query the records themselves. It was quite a cumbersome process. Those who used to register, notably the Kenya KWFT, you'd find that they used to come with bulks of documents to register. And you can only imagine querying that system, how long it will take. So you'd make a search request, and it will take 2 months for you to get an output. And remember, when it comes to a financing, time is of essence. You need to know the risks that are attached to a particular collateral. Because of all this, conducting due diligence, paying stamp duties, it used to be a very expensive affair in terms of time and cost. And then you'd find that the fact that querying the regime itself was cumbersome, it was quite difficult to enforce because you don't know which law will be applicable. So you'll find that most of the people will choose to use the law that is favorable to them. And then there was quite a compromise in terms of who has a priority over, if it's a motor vehicle that has been used to secure credit. You couldn't easily tell who has a priority over that property. And then because it was quite limiting in terms of what assets could be used to access credit, you'd find that financial exclusion was quite a huge thing. And because of that, there was a reduced amount of lending. However, our next slide, Zakaria, with the coming into force of the movable property security rights regime, even from the statistics, we can clearly see that there has been an increase of access to credit. And this is largely because most of the banks are now feeling comfortable because they have a system to query. And when it comes to mitigating their risk, then at least they have a platform to which they know where they rank when it comes to priority. There has been, increase of access is linked to the fact that there is a reduced risk of credit. And then there's also a reduced risk, the reduced cost of credit. I've talked about the stamp duty that used to be applicable. Definitely, when there is a cost attached to financing, it boils down to the borrower. And because that has been are taken out, then the cost of credit has gone down. You'd find that even the agreements themselves, you don't need to be too verbose in terms of I'll talk about how simple an agreement can be. And so you don't need, I'm sure a lot of lawyers are in the room, but you don't need the services of the lawyers for you to come up with an agreement. So in terms of cost, there's a reduction of cost. And from the bank side, we find that the regime has promoted credit diversification. So what can be used to
Gadi, we have lost you.
Kindly give us a few minutes to get Shigadi back on. I think she has dropped off. We apologize. Kindly give us a few minutes. We'll be back shortly after we fix a few issues. I can see someone asking whether we have any sound, but well, it is because one of our presenters dropped off. But I think as we wait for her, we could take a few questions so that at least we do not have that gap. Well, as we know that the questions will be coming up later, so we can just take a few, especially on the BO and annual returns, which are already been presented as we wait for Shigadi. Patrick?
All right, thanks, Zakaria. Hi, folks. Please just drop your questions on the chat box as we're waiting for Shigadi to join in. There's been a little bit of technical hitches here and there, but we hope she sorts this soon. Meanwhile, just drop your questions while she's back. We could proceed.
Patrick, can you hear me? Apologies for that. I dropped off.
Yeah, sure. We can hear you. Please proceed.
Okay, Zakaria, just project. Next. So the MPSR regime has broadened the scope within what can be used as security to access credit. Notably, I'll talk about the negotiable documents. You'd find that with the coming into force of the warehouse receipt council now, you can use the warehouse receipt that has been issued from the warehouse receipt to approach a bank, and you're able to access credit. And then, of course, we have the traditional ones like the motor vehicle that have previously been commonly used. And from our statistics, you'd find that household goods and equipment are quite used to access a credit. Next. So I'll briefly talk about the approach that this regime takes. So the MPSR regime takes a functional approach, which means that it subjects all the transactions to that secure an obligation to the movable assets. And the scope of it, I'll speak about the retention of title aspect, whereby you can have where I'll give an example of a supermarket. You'd find that suppliers would supply goods on credit to a supermarket. And in turn, what they indicate is there will be a clause whereby they say, we'll still retain a title until you pay off the goods. The net effect of this regime is that if, as now the supplier, you do not register your interest over the said property or the goods that you've supplied to the supermarket, the net effect is, should the supermarket be declared insolvent, and a case being that there is a particular bank that issued loan over all the assets of the supermarket, then should the supermarket be declared insolvent, what it means is that when the bank now, who they could appoint their own liquidators to that effect, then they will reprocess all the property that belongs to the bank. And if the supplier did not register under this regime, they will ultimately suffer a loss, which means that the bank will be paid in terms of priority because the bank was able to register all present and future assets of this particular supermarket. Then the bank will be able to be paid first before anyone else. And if the individual did not register under the MPSR, then they stand to lose. Another component I'll talk about is in relation to motor vehicles, you'd find that most of the banks do register as, or the financials do register as co-owners under NTSA, which is fine. But you'd find that should now that car, for example, be involved in an accident, or should the individual be declared bankrupt, then the bank will stand to lose. When they go to court, for example, if it's an accident, then the court will interpret that the fact that you're registered as a joint owner in that logbook, then you are indeed a joint owner by virtue of you having not registered a security interest, and you will be held liable equally with the person, the borrower. Next slide. So how do you create this security interest? The only way that you can create a security interest is by way of an agreement between the debtor and the creditor. And if the borrower is not necessarily the owner of the vehicle, you need to ensure that the borrower has a right to encumber the said asset. Next. So like I had previously indicated, a security agreement, you nowadays don't really need a lawyer. However, we always want to feel safe, and hence we bring them on board. But it can be as simple as long as you're able to identify the parties in the said agreement, you identify the collateral, you identify the secured obligation, then it meets the requirements of the movable property security rights, and to this end, then you have been able to secure to create a security right which can be registered under the MPSR Act. Next. So yes, you can have that agreement, but the only way for you to ensure that as a secured creditor, your interests are protected, you have to ensure that you register this collateral. So the only way to perfect it is through registration. Next slide. And the purpose of actually registering is so that it can be known out there. Should there be a default, then as the secured creditor, you have a priority over everyone else who comes after you. And this is majorly because we appreciate the fact that a particular asset can be used by multiple financials to secure this interest. And so when it comes to default, it is important to clearly outline who will have a right of priority, who will have a right to exercise enforcement. And even if they decide to give it up to someone else, in terms of payment, who will have the right to realize their proceeds. Next, Zakaria. So you'd find that, of course, for every rule, there's an exception. So the exception to this is in the for buyers in the ordinary course of business. And then you'd find that from my conversation right now, I've only talked about the secured creditor. However, the consensual creditor, whereby it's between a debtor and the creditor. But you'd find that there are instances where you would now have to, just a minute. There are instances where you'd find that there can be an arrangement where there is an unconsensual creditor. For example, if you're a judgment holder, then it is very important that much as you have been given that order by court, it is important that you also register your interest such that should there be if there is an insolvency proceeding going on, then it should be known that you should be the one, you have a priority over the assets of the said individual. Equally, the official receiver, a landlord representative, even KRA are also required to register their interests under the movable property security rights. Next slide. So in terms of enforcement, the first rule is that before you enforce, there has to be a default. So that's the only way that an individual can proceed to enforce. So whether the debtor has failed to pay, or there was a specific obligation that they were required to perform and they have not been able. And the methods within which you can exercise this is one, you can either apply to court, or two, you can enforce in accordance with either the agreement that you have or the MPSR Act itself. Next slide. So in terms of reliefs for non-compliance, you'd find that it is a requirement that the secured creditor notifies the grantor that you have defaulted, and therefore we intend to proceed to enforce. And so where the grantor fails to comply. Now, these are some of the reliefs that the secured creditor is able to exercise. One, they can sue the grantor for any payment that is due, and then they can appoint a receiver who will take over the asset, and if it means selling so that they can realize the proceeds, then and you're paid off, and then they can opt to lease the asset, so that from leasing the benefits that they get, then you can be paid off. Or the secured creditor, if the terms of the agreement indicate this, then they can take up possession of the car that was used to secure credit. Lastly, they can, opt to sell the particular asset so that they can realize their profit. And of course, they can pursue any other remedy that they have provided under their agreement. Next. So the duties and rights of parties in a secure transaction regime include the grantor, the owner of the asset, has a duty to ensure that the collateral is preserved, it's taken care of, and the secured creditor is required to, when there's need for an amendment, they have a duty to ensure that an amendment is effected in the registry. If someone has already paid their dues, I'll talk about the cancellation notice. Then it is the mandate of the secured creditor to ensure that they have amended the notice. And then the secured creditor has a right to inspect the assets. Maize in a farm, they have a right to just walk in there and ensure that the farmer is really taking care of the maize that are there. And then the right for reimbursement for expenses, if there are any expenses that have been incurred by the secured creditor owing to, the actions of the grantor, then they're entitled to repayment. And lastly, they have a right to notify the person who owes the debt. So this happens where a debt has been transferred by the grantor. So the grantor has a right to notify the person they owe, that who owes a debt to them, that they can pay the secured creditor. Next. The secured creditor has various duties that they have to exercise under the Act. One, they must send a notice to the grantor within 10 days of filing the initial notice. This is a mandate under the law, and they need to, and as a secured creditor, if you're lawyers, this is something that you have to encourage the banks to be doing. And the net effect of this is, should there be a mistake under the initial notice, then it can be easily detected at an early stage, and an amendment notice can be filed. Another thing that a secured creditor is required to do is the Act provides 10 years as a limit within which the registry can store an initial notice. So what a secured creditor is required to do is, if you have entered into an agreement and the time is, say, 12 years, the time of repayment is 12 years, 6 months prior to the expiry of 10 years, you are required to log into the system and file an amendment notice to that effect, because once the 10 years lapse, then the the initial notice will cease to exist in the system. And this will mean that you will end up losing your priority. So it is very important that you keep tabs of the time that is allocated. And then they have a duty to scrutinize and verify the information that they submit. One thing I want to highlight is the registrar has no way of amending a notice. This obligation solely lies with the secured creditor. I would really want to emphasize on this because we found instances whereby now, 5 years later, banks are coming to us indicating that kindly amend the initial notice on our behalf. And the reason being is the application was made in an individual account, not the bank's account. So like I've indicated, it is the registrar has no button to amend or cancel a notice. The onus is on the secured creditor to ensure that they amend or cancel in that case. So in instances where an individual has registered in their own account, what we normally advise as the registry, that which is all you can do, is advise that the banks contact the individual who was their employee at that time to transfer that application to the bank's account. Sometimes it works, sometimes it doesn't, and the registrar is now forced to contact the said individual to ensure that they transfer. And what we do is we normally just guide them through the whole process of transferring that application to the bank. So this MPSR Act brought on board the equilateral registry, and it has brought certainty, which is something that if you are when you're conducting your due diligence, this is something that you really want. You want to know, has this asset been used before, and if it has, what are the implications if I opt to go ahead and issue a credit over the same asset. So the registry is fully electronic. We don't admit any uploads. That's one thing. We don't admit any uploads. We've had instances whereby people are indicating that we took a photo of a cow. Can we upload the photo of the cow? That can be attached in the agreement note under the registry. It's fully electronic and it can be accessed in real time. When you log in, you register your initial notice, you get an output immediately. When you query the system for a search, as long as you have the correct unique identifier, you're able to get the output immediately. So in terms of searches, all we need is it can be searched by either the grantor's ID. If it's a company, then the registration number. If it's an entity that has been formed by virtue of an act, then the Act of Parliament. And then what is unique about this registry is only in relation to motor vehicle. You can search using the motor vehicle chassis number. But if you want to do a general search, then you can use the unique identifiers that I've talked about. The only thing that we charge under this registry is the fee for conducting a search, which is quite minimal. It's 500 shillings. The rest of the applications are free. Next, Zakaria. Like I have indicated that the registrar is quite limited when it comes to this registry. So we don't validate the information that is keyed in. We don't verify, because the purpose of this registry is to ensure that the secured creditors have their rights secured. And so it is the onus of the secured creditor to ensure that the information that they key in is correct and is accurate. What the registry does is just to ensure that all the mandatory information that is required are filled, and by this you cannot proceed to the next step until you have complied. And then the registry has a responsibility the registrar has the responsibility of ensuring that the information is available, be it an initial notice that has been lodged, then the registrar has an onus of ensuring that when a request is made, that information can be auto-populated. The only thing that I think you cannot proceed if you have not keyed in the required information, and if you fail to pay a particular fee, then definitely you can't get an output. Next, Zakaria. Zakaria, next. So under the registry, we have various notices. We have an initial notice, we have an amendment notice, a cancellation notice, and you can query the system to conduct a search. Next. Under the initial notice, there's some information that we require, and I'll want to be specific about this in that you really have to ensure that you key in the correct details of the secured creditor, the grantor, and the description is correct. This is because there has been a case in court where the secured creditor did not key in the correct identifier of the grantor, and the correct identifier in this case was the company reference number. So the information that was keyed in was not a true reflection of who the actual company is. And so that particular secured creditor ended up losing. It was quite a huge amount of money. So I would urge that we be very careful when we're keying in the details of the grantor, the secured creditor, and equally the description of the collateral. You have to make sure that the description that you have given is able to identify the said collateral that you're referring to. Then the initial notice always requires that you give a period of effectiveness of the security. We definitely have some information that we normally query, but this is just for statistical purpose. Next. So if you realize that you have lodged an initial notice and you find that the authorization that you were given by the grantor is outside the scope, then you are required to ensure that you file an amendment notice. I've indicated that this is free. And if the secured agreement has been revised, then definitely you have to ensure that you amend that notice. If there has been a change in the grantor identifier, this is very important. You have to ensure that this is also amended, and it has to be amended within 60 days just to avoid losing on the priority rights. And then lastly, if the ownership of the collateral has been transferred to a new owner, and the owner has agreed to acquire it with the liability, then you also need to amend the same within 10 working days. Next. Lastly, in terms of what the registry can take is a cancellation notice. This can be filed on termination of the security rights in the collateral, or if the initial notice was not authorized by the grantor, you'd find vindicated that a grantor need not be a borrower need not be a grantor. So the owner of the asset is the grantor. I could use my sister's car to secure credit. So if you find out that the authorization was not given by my sister, then definitely you are required to lodge a cancellation notice. And if the authorization is withdrawn, if my sister decides to withdraw the authorization, then you are required to file a cancellation notice. And if the security right has been extinguished, then definitely you have. This is an obligation that is placed on the secured creditor. And I've had a number of questions to the effect that if the period of effectiveness has lapsed, do I really need to come back to the registry and cancel the notice? Yes, it's an obligation that has been placed, and it's always in the agreement. So you are required to ensure that you lodge a cancellation notice once someone has fulfilled their obligation. That's it from the MPSR registry. Patrick?
Hi, Shigadi, thank you for our presentation. And I think we'll just take the questions, but I've seen most of them have been responded to. Well, there's some that are streaming in, around 4 of them. So allow me to read the ones that you haven't responded to. So Marcin Dungu asks, have any security rights been registered over intellectual property rights? And how can one go about doing this? So what can BRS do to ensure that financial institutions have confidence that they can realize their right should the need arise? That's the first question from Marcy. Then Wilfred Kabugi asks, hi, can we get the recording after this? Well, we'll organize. Then for Marcy, again, Marcy Dungu asks, is it mandatory to have valuation of the asset to ensure it is commensurate to the amount of debt, like how there is valuation for land? Then there is an anonymous attendee. He asks, or she asks, is it a requirement to upload? I guess that's what she or he meant. Is it a requirement to upload the agreement creating the security? And if not, how can BRS ensure that notices are not being created on a whim? Fair enough. So those are the 4 questions I have right now. And then there's one who had also asked whose side barred me, and she asks, are there any other consequences other than fines when a company fails to file annual returns? And then her last question was, what transactions are companies not permitted to do if they don't have updated annual returns? So those are the 4 questions I have. So the panelists, you could kindly respond to those, and I think we can wrap up after that. Thank you.
Patrick, I have to admit I was only to get the question on agreements. I didn't get the other 2. Were they directed to me?
Well, there's yeah, for the agreements, yes, that's directed to you. I think Zachariah, could you pick up the other 2? And for the company, the last 2 questions that I've read, perhaps Shigadi, you can just proceed and respond to the agreement one, and then I could read the others for Zachariah and Anna. Thanks.
Thanks, Patrick. So I have indicated that the registry does not allow any uploads. And an agreement, this is something between the 2 parties. The purpose of this registry is to notify people of the interest in that particular registry. So in our case, we don't allow an upload of the agreement. And okay, the other question was, how do we ensure that the notices are not being created? As BRS, this is a platform for the benefit of the secured creditor and for the benefit of the borrowers, just to reassure the financial institutions that to enable them determine the risk that is attached to the said collateral should they opt to issue credit using the same. Thank you. I hope I've answered your question.
Yeah, so Marcy's question, I think she has gotten the response already. Then there was also the one to do with the IP rights. I don't know if you heard of the same. Shigadi.
Sorry, Patrick.
There's the other question that Marcy asks, and she said that she asked that have any security rights been registered over IP rights? And how can one go about doing this? And what can BRS do to ensure that financial institutions have confidence that they can realize their right should they need the rights?
So yes, we from the statistics, we find that intellectual property has been used to secure credit. And Mercy, that's the essence of the registry, to ensure that the secured creditors feel confident enough, because you'd find that a financial will not be easily lent if they're not sure that their interests are taken care of. And the essence of this registry is to ensure that the moment you registered your interest, then you have a priority over anyone else who will come after you to issue credit using, say, the state intellectual property. And one thing that we moving forward are going to do is we intend to collaborate with PP such that we can ensure that there is integration of the two systems. Thank you.
Fair enough. There's one lady here, her name is Caroline. I think perhaps the question has been responded to. But Zachariah, the last two questions are on. You can take this up, where someone asks, are there any other consequences other than fines when a company fails to file annual returns? I think one of these consequences was addressed during a presentation. So perhaps if there are other alternatives, you can also mention the same. And then lastly, what transactions are companies not permitted to do if they don't have updated annual returns?
Okay, thank you. Thank you for the questions. In terms of annual returns at the moment, we have a few restrictions that we have imposed on companies. And you'll notice that if you happen to link your company without having filed your annual returns, we restrict the business to only filing annual returns. And that means that you're not able to make any application for change of officials. You're not able to make any application for official search. So therefore, the only thing that you can do with that particular entity is to file annual returns. And once that is approved, you are now free to make any other change in the company. And that is to make sure that every company is compliant with filing every notice that is required by the registrar. So I think that covers all the questions in relation to annual returns, unless there is something else. I saw something else in the chat, which probably I would like to mention. There was a question about identification of companies on the search. And I think I had responded that the search is able to capture that information, but I think this could be in relation to a new search which we're working on. I think the old ones, from what I've checked in the records, does not contain the type of company. It only contains the company name, company number, the shares, and all that. So maybe just to mention a quick way of identifying a type of company if you've been issued with a search. We have different types of numbers allocated to different types of entities. And allow me to touch on the companies which were registered manually, because that is where we may have a challenge with identification. For companies which were registered manually, the registration number for private companies would start with C dot and then a numeric number. So let's say it will be C C.123. So you find a company or a search which you produced bears that kind of registration number, then that's a private company. Then if the company is a public company, it will bear a different type of numbering, which will be C dot, let's say 1/2. So there will be a stroke in between two numbers. So it will be something like C dot 1/2. And that is an indication that that company is a public company. Now, when you move forward to other systems that you've used over time, especially the current one, you'll notice that for PVT, that is private limited companies, CLGs, that is for companies limited with guarantee, and for public limited companies, that is PLC. So I think that would be an easy way of helping users to identify the types of companies that they get the searches for. But I believe in the current system that we're working on, that information will be captured. As to say, the type of company will be captured in the search, because I think I have a sample here of the developed template which bears that information. So I think that should answer the question on how to find out whether a company is public or private given a search.
Okay, fair enough. And perhaps the last two questions now before we wrap up. There's one person named James. James is asking, could you explain the file perusal issues and when we can expect encumbrances to be updated online as well? Searches undertaken online do not usually reveal encumbrances, and the file perusal is not always accurate, as we rely on the person or clerk undertaking the search to go through encumbrances already filed. And then the last question should be from Alexander Mutinda. Alexander asks, kindly, rather, would like to seek for your advice on the same. Kindly advise if you have a direct contact line for financial institutions, such as banks, in instances where business names or a company has initiated verification process and it has been pending for a while. Yeah, so yeah, just address those two and then we can wrap it up. Zachary? Or Anne,
Okay,
you can take this up.
Sorry for that. Maybe we can start with encumbrance. You will notice that we are in the process of moving the physical files to digital formats, which will enable us to update all information relating to companies. And that means that not all charges which had been filed by companies will be available. And therefore, we can only at this point say that all the old charges which were filed by a company at the moment will only be identified using the perusal method. But as we go, we keep on updating this particular information, and we are looking forward to a time where all that information will be updated and will appear on the search. However, we have a few clients who have approached us to update that particular kind of information, and we always make sure that we do. So in case a client finds themselves in a difficult situation, they're welcome to bring the issue up, and the relevant team will update that particular record. I think I might have missed the last question, Patrick.
Well, the last question wasn't really a question per se, but an advisory. Someone seeking an advisory on a direct, on whether there is in existence a direct contact line for financial institutions such as banks in instances where business names or a company has initiated verification process and it has been pending for a while.
Okay, at the moment, no. Banks usually come here or contact us through other means or hire advocates to actually make the follow-up on their behalf to verify the information that is held with us. So at the moment, no, but I believe there is every intention to make sure that at least we have some form of contact with these financial institutions, so that at least any client who seeks any kind of service from the bank is able to get a quick response by the bank, easily accessing the information held by us and updating the same, or notifying the client of the outcome of their search. I believe the question was in that line, unless I can get
Yeah, I
it
mean,
further.
I thought the same too, because there is a little bit of ambiguity in the same, but nonetheless, you've responded to that. And I think the last one, last, that what someone is asking, Joe is asking, what does it need to do to get a current CR12? Zachariah or Ran, and please, yes.
Patrick, the process
Yes.
of applying for CR12 is on eCitizen. So, Joe, what you need to do is make an application for a current CR12. It's simple. Everything is on eCitizen. But if you're having any issues, please, I will share my email. I think we'll all share our emails just in case someone has an application that maybe has taken some time, the big process, or you're facing any problems. We have an open door policy. I'll share my email just in case you're having any issues, then you can always reach out. But the application for CR12 is online.
Joe, just to add, it depends. You're requesting that CR12 as, is it a third party? Is it a director? If you're doing it in your capacity as a director or a shareholder, the one thing that you must ensure is that the company has been verified. That's the first step. And then once that has been done, then the CR12 is auto-generated. If you're doing it as a third party, there's a third party search under the eCitizen, and you can be able to obtain the CR12. Thank you.
Great. So, ladies and gentlemen, thank you for being part of this webinar. I do appreciate your time and your resourceful minds for making this a success. And gratitude as well to the attendees for creating time. While this has been quite an informative session, and we hope to do this quite often if time allows. But for now, I think it marks the last of our, two series webinar. We did the insolvency webinar, and now we've done the MPSR and company law. So we can only build on the foundation that we've created at the moment. And we will see how to share the recording with you for reference. Perhaps what we'll do, I'll figure this out. But for now, I think it's time maybe to adjourn the session. I've been your moderator, Patrick, and I hope to keep on bringing such webinars to life, because there is need for sensitization, there's need for awareness, so that we have to do what is right and not what is easy. And I do appreciate, again, BRS for always being available to partner and collaborate with KEPSA to ensure that at the end of the day, we do create an enabling business environment, but that has to first begin by sensitization for our members and even the attendees in today's session. So thank you, ladies and gentlemen, and looking forward to having you once again next time, inshallah. So allow me to join the session, and guests may leave with their own pleasure. Thanks.
Thank you for having us, Patrick.
Bye.
Bye-bye.
Bye. Good day, everyone.
Good day. Enjoy your afternoon.
Thank you. Bye.